commodity, more institutional outbreak. And it's arguable that most people consider that very sensitive information. We have three panelists that are going to talk about various aspects that deal with financial information and privacy. Our first speaker is Alexandre Plourde, who's a graduate of commercial and lawyer. He has particular interest related to privacy protection and often leads information such as identity theft. He has done work with OPC confusion program. Our second speaker will be Dr. Avner Levin, who's associate professor at the Rogers School of Management and chair of law and business at Ryerson University. He has held various positions at Ryerson, and his research interest includes the protection and legal privilege of personal and private information, both locally and internationally. And our final speaker is Dr. Cockfield, who's a professor at Avner University. Along various interests and research work that Cockfield has done, some of them have focused on tax law as well as law and technology theory and privacy laws. Our first talk will be on new services provided by credit agencies, will be French. So I believe there was a notice about using mics. Your French is not exactly up to par, such as mine. I believe it's running on channel 1, so if you turn it on, it should be fine. And on that note, I'm turning to Alexandre.
Merci. Donc, effectivement, je suis Alexandre Plourde, avocat chez Consommateurs. C'est une première pour moi de participer à un symposium de la sorte, donc je vous remercie de m'avoir invité. C'est très apprécié. C'est même un honneur. Alors, je vais essayer d'être le plus bref possible. Vous savez probablement, les agences de crédit recueillent beaucoup de renseignements personnels sur les Canadiens. Elles recueillent non seulement des renseignements sur les habitudes de paiement des consommateurs, mais aussi d'autres renseignements comme leur adresse, leur date de naissance, et même des renseignements sur leur emploi. Ces renseignements personnels, qui leur sont principalement fournis par les créanciers des consommateurs, sont colligés dans ce qu'on appelle un dossier de crédit. Les entreprises, moyennant des prêts, peuvent consulter le dossier de crédit des consommateurs desquels elles ont obtenu évidemment le consentement. En vertu aussi de la loi, ces derniers, les consommateurs peuvent aussi en obtenir une copie gratuitement. C'est ce qu'on appelle le droit d'accès. Les agences de crédit ont aussi développé, en plus du dossier de crédit qu'on connaît, un outil qui, du moins selon elles, permet aux créanciers de mieux évaluer le risque que représente une personne qui demande du crédit. Il s'agit du pointage de crédit, un nombre de 3 chiffres calculé à partir des renseignements personnels figurant au dossier de crédit. Le risque que représente un consommateur est exprimé par un chiffre qui varie entre 300 et 900, 900 étant le meilleur pointage. Chez Option Consommateur, nous avons souvent l'occasion de nous intéresser aux pratiques des agences de crédit. Nous offrons des services budgétaires directs aux consommateurs et aussi des services juridiques directs aux consommateurs, étant à l'occasion des services qu'on donne aux consommateurs individuellement. On a évidemment eu l'occasion de beaucoup de problématiques liées aux agences de crédit qui nous ont été portées à notre connaissance. Nous avons d'ailleurs déjà réalisé plusieurs autres études sur la question des agences de crédit et ou des problématiques qui lui sont connexes. Donc, dans le cadre de notre travail, nous avons réalisé que depuis quelques années, les agences de crédit semblent exploiter au maximum les renseignements qu'elles détiennent sur les consommateurs canadiens pour ensuite les vendre à leurs clients. Au-delà des deux outils classiques qu'elles offrent, donc à savoir le dossier de crédit, le pointage de crédit dont je viens de parler, elles ont aussi développé d'autres services et des pointages de toutes sortes. Donc, la recherche que je présente ici brièvement aujourd'hui, qui a été réalisée dans le cadre du programme des contributions CDVP, se questionnait globalement sur la légitimité de l'utilisation des renseignements personnels à ces nouvelles fins pour ces nouveaux services. En ce qui concerne mon exposé d'aujourd'hui, je vais me limiter seulement à étudier deux questions qui sont abordées dans cette recherche, à savoir quels sont les nouveaux services des agences de crédit et les consommateurs sont-ils suffisamment informés sur ces nouveaux services? Donc, quels sont les nouveaux services des agences de crédit? Dans le cadre de notre recherche, nous avons observé plusieurs phénomènes dans l'évolution
dans l'évolution des services des agences de crédit au cours des dernières années. Premier phénomène, les consommateurs n'ont jamais été autant affublés de pointages de crédit différents. Aux États-Unis, on dénombrait ainsi 49 pointages fiscaux différents en 2012, sans compter tous les autres types de pointages qui peuvent exister. Au Canada, on retrouve une même diversité de pointages. On retrouve en fait toutes sortes de pointages qui visent, par exemple, à évaluer la possibilité que surviennent des scénarios précis. Par exemple, le risque de faillite d'un consommateur au cours des 24 prochains mois, ou à évaluer des types particuliers de consommateurs, par exemple ceux ayant peu de renseignements dans leur dossier de crédit. Ultimement, tous ces pointages se ressemblent avec des différences significatives entre eux que dans une faible minorité de cas. Donc, une personne ayant un bon pointage générique aura aussi un bon score pour tous les autres algorithmes qui existent. Parallèlement à la diversification et la multiplication des pointages de crédit, on remarque aussi une diversification des utilisations du dossier de crédit. On recourt aux données du dossier de crédit dans un grand nombre de domaines. En matière d'assurance, on utilise un pointage d'assurance pour fixer le montant des primes. En matière d'emploi, pour déterminer l'employabilité d'une personne. En matière de logement, avant de louer un appartement à un consommateur. En fait, les agences de crédit semblent chercher de plus en plus à offrir des services visant à répondre aux besoins précis de chaque créneau de clientèle qu'elles desservent. Il y a d'autres services, évidemment, qu'on retrouve. Les renseignements personnels détenus par les agences de crédit peuvent aussi être utilisés pour aider les entreprises à cibler leur publicité. Donc, on parle de services de marketing ici. Il y a d'abord des services destinés aux entreprises qui veulent promouvoir des produits auprès de leur propre clientèle. Dans ces cas, si l'entreprise a obtenu le consentement de ses clients, elle peut utiliser les données du dossier de crédit pour faire la segmentation de sa propre clientèle. Mais on trouve aussi des services destinés aux entreprises qui veulent promouvoir des produits auprès d'une nouvelle clientèle, auprès de consommateurs dont elle n'a pas obtenu le consentement pour utiliser les renseignements personnels à cette fin. Dans ces cas, comme le consentement n'a pas été obtenu, les agences de crédit fournissent des données dépersonnalisées, habituellement agrégées par code postal, qui regroupe au minimum une dizaine de consommateurs, du moins selon les dires des agences de crédit. Avec ces données dépersonnalisées, l'entreprise ne peut donc pas cibler individuellement les consommateurs, elle peut cibler sa publicité par quartier ou par zone géographique. Autre service, les agences de crédit offrent aussi des services de sécurité basés sur les renseignements qu'elles recueillent. On propose d'abord d'identifier les consommateurs à l'aide de leur dossier de crédit. Le principe ici est simple. Il s'agit de comparer les données du dossier de crédit avec les réponses que donne le consommateur aux questions qu'on lui pose. Par exemple, pour vérifier son identité dans une application en ligne, on pose des questions à choix multiples à un consommateur sur les comptes de crédit qu'il détient, sur ses anciennes adresses ou sur les paiements mensuels qu'il a à faire sur ses comptes de crédit. En présumant, évidemment, que s'il donne des réponses exactes, il est la personne qu'il prétend être. On propose aussi aux entreprises de les aviser de risques de fraude potentiels, encore là en se basant sur les données du dossier de crédit. Par exemple, si un consommateur a une activité à son dossier jugée douteuse par l'agence, elle pourra aviser l'entreprise du risque envisagé par rapport à ce consommateur. Il y a aussi des services qui sont destinés directement aux consommateurs, c'est-à-dire des services payants destinés directement aux consommateurs. On lui offre, moyennant les frais, un accès instantané via Internet à son dossier et à son pointage de crédit. On retrouve aussi toutes sortes de forfaits offerts aux individus qui permettent, par exemple, l'accès illimité au dossier de crédit, l'obtention d'explications sur l'interprétation qui sera faite de leur dossier, des notifications par courriel d'indices de fraude à leur dossier. On offre même des assurances contre le vol d'identité. Ces services-là ne sont pas négligeables en soi, ils peuvent représenter jusqu'à 10% des revenus des agences de crédit. Finalement, un dernier phénomène qu'on remarque dans l'évolution récente des services des agences de crédit, c'est tout ce que l'informatique a permis de faire au cours des dernières années. On remarque deux choses en fait. D'abord, tous les services que je viens d'énumérer, que je parle de marketing, qu'on parle de diversification des pointages, qu'on parle de services de sécurité, peuvent être livrés dans des interfaces automatisées. On parle ici de logiciels qui permettent aux entreprises d'intégrer les services des agences de crédit à leurs règles de gestion usuelle pour prendre des décisions automatisées sur les consommateurs. L'informatique et Internet permettent aussi d'effectuer un suivi beaucoup plus constant en temps réel du dossier de crédit d'un consommateur, duquel, évidemment, on a préalablement reçu le consentement pour ce faire. Les agences ont ainsi, autant pour des fins marketing que de prévention de la fraude, de donner à leurs clients des notifications lorsqu'il survient certains changements au dossier de crédit d'un de leurs clients. Par exemple, une agence de crédit peut aviser une entreprise qui est sa cliente qu'un de ses clients vient de changer d'emploi, vient de déménager ou vient de déclarer faillite, et l'entreprise peut évidemment réagir conformément à ses règles de gestion. Donc, ça fait un portrait très succinct des nouveaux services, de ce qu'on qualifie de nouveaux services dans le cadre de cette recherche offerte par les agences de crédit. Qui nous mène à la seconde question que je voudrais traiter aujourd'hui. Les consommateurs sont-ils suffisamment informés sur les services offerts par les agences de crédit? Je commence par un aparté. Savoir précisément comment les agences de crédit génèrent des revenus avec les renseignements personnels des consommateurs est une tâche ardue. Les agences de crédit étaient évidemment peu ouvertes à nous accorder des entrevues et on n'a pas trouvé non plus d'études qui énuméraient de manière exhaustive leur offre de services, même si certaines publications, surtout américaines, en parlent occasionnellement. En somme, l'information divulguée au public sur les services offerts par les agences de crédit demeure limitée. Pour contourner le problème, nous avons consulté la documentation promotionnelle des agences. Donc, on parle de la publicité, des sites Internet, des infolettes, des communiqués de presse annonçant de nouveaux services. On a aussi consulté les rapports financiers des agences de crédit, particulièrement ceux émis en vertu du Securities Exchange Act aux États-Unis, qui mentionne encore là occasionnellement les services offerts au Canada. On a complété évidemment notre recherche par des articles universitaires, des études d'autres organismes privés ou publics et même des articles parus dans les médias. Bien qu'il nous ait été possible, au terme de cette recherche, de dresser un portrait suffisamment précis pour soulever les enjeux pertinents en matière de vie privée, il faut noter que manifestement, premier constat, il est difficile pour le consommateur moyen de savoir quels sont exactement les services offerts par les agences de crédit. Dans le système des agences de crédit canadiens, c'est aux clients des agences, c'est aux entreprises qu'on délègue la responsabilité première de remplir les obligations légales en matière d'information du consommateur et d'obtention de son consentement. Donc, nous avons analysé les formulaires et les contrats types utilisés par les principales banques canadiennes afin de savoir comment exactement les consommateurs sont informés sur les nouveaux services dans ces documents. On a aussi analysé les politiques de gestion des renseignements personnels de ces institutions financières et aussi celles des agences de crédit, Equifax et Transfert. Finalement, on a effectué aussi des entrevues avec les consommateurs dans le but de savoir notamment ce qu'ils savent des utilisations qui sont faites dans leur dossier de crédit et ce qu'ils en pensent. On a d'abord constaté que la plupart des formulaires de consentement des banques adoptent une structure équivoque qui laisse l'impression que la banque s'autorise à effectuer toute collecte de renseignements personnels pour n'importe quelle fin. Par exemple, on annonce une liste générale de types de renseignements pouvant être recueillis, une liste générale de types de fin de la collecte, mais ces types de renseignements recueillis ne sont généralement pas rattachés à des fins spécifiques. Les agences de crédit sont mentionnées, mais on ne sait pas exactement quelle est la limite des fins d'échange d'informations entre elles et les institutions financières. En somme, il est complexe à la lecture de se faire une idée exacte de ce à quoi consent le consommateur. Certains formulaires apportent tout de même des précisions. On peut y mentionner explicitement, par exemple, que des renseignements personnels seront ou pourront être recueillis auprès des agences de crédit pour fin d'évaluation du crédit ou de vérification de la solvabilité. Cependant, ces clauses spécifiques se trouvent aux côtés d'un énoncé général très permissif et il reste alors difficile de savoir ce à quoi on consent. De surcroît, on ne donne pas non plus d'informations aux consommateurs sur les utilisations éventuelles qui seront faites de ces renseignements personnels, c'est-à-dire des services de vérification d'identité, de marketing ou de suivi en temps réel offerts par les agences de crédit. Si, théoriquement, l'obligation de la banque se limite à informer le consommateur uniquement des utilisations qu'elle fera elle-même des renseignements personnels, peut-être qu'une véritable transparence dans le contexte des agences de crédit devrait exiger de donner des indications plus poussées à cet égard. Tous les formulaires des banques qu'on a analysés invitent le consommateur à consulter la politique de gestion des renseignements personnels de la banque pour obtenir plus de détails sur ces pratiques. Ces politiques complètent parfois effectivement les formulaires des banques. Ainsi, on peut donner des exemples de renseignements personnels recueillis par la banque dans les cas où ces informations étaient manquantes sur les formulaires. Mais ces politiques demeurent rédigées de manière très générale, s'appliquant à toutes les pratiques d'institutions financières et donnent des indications globales sur l'échange de renseignements personnels avec les agences. Pour avoir plus de détails, on y invite à nouveau le consommateur à se référer aux clauses des formulaires dont on a fait l'analyse. Bref, les documents que le consommateur signe réfèrent aux politiques des banques pour plus de détails. Ces politiques, qui sont hors générales, réfèrent à leur tour aux documents contextuels pour obtenir plus de précision. Un étrange aller-retour pour le consommateur qui laisse au moins une question en filigrane est-il légitime de lui demander de parcourir plusieurs documents pour tenter de comprendre ce à quoi il concerne. On a aussi analysé les politiques de gestion de renseignements personnels des agences de crédit elles-mêmes. On y a trouvé peu de choses. Il faut en faire une lecture attentive pour y trouver quelques mentions sur les services précis qu'elles offrent. De surcroît, on délègue essentiellement, encore là, aux clients de l'agence la responsabilité de remplir les obligations d'information et d'obtention du consentement. La lecture de ces politiques de gestion des renseignements personnels et des clauses de consentement contractuel des banques nous a d'abord amené à nous interroger sur le respect de la loi. Selon le principe 4.4 de la loi fédérale, la collecte ou la communication à laquelle le consommateur consent doit être claire et ne peut donner à l'organisation la possibilité de recueillir un nombre illimité de renseignements. En somme, l'information donnée doit être suffisamment précise. Les stipulations trop vagues, trop générales, ont été jugées insuffisantes, par exemple, dans les conclusions du CPVP, même si les fins évoquées pour justifier la collecte, l'utilisation ou la communication sont acceptables. Ici, du moins, on peut se questionner à savoir si tous les intervenants de la chaîne d'octroi du crédit au Canada, c'est-à-dire les institutions financières et les agences de crédit, font conformément au principe 4.3.2 de la loi fédérale un effort raisonnable pour s'assurer que la personne est informée des fins auxquelles les renseignements seront utilisés. Du moins, on peut se demander si l'esprit de la loi est respecté. Quoi qu'il en soit, il y a une chose qui est certaine, il apparaît nécessaire d'informer davantage les Canadiens sur la façon dont les agences de crédit génèrent des revenus avec leurs renseignements personnels. On a fait le constat lors des entrevues que les consommateurs ne connaissent pas les services offerts par les agences de crédit et certaines pratiques, telles que l'utilisation du dossier de crédit à des fins de marketing, sont généralement peu acceptées socialement. Donc, au regard de tout ça, plusieurs solutions peuvent être envisagées pour mieux informer les consommateurs. Une première piste de réponse pourrait être de modifier les lois sur la protection des renseignements personnels, comme j'ai entendu précédemment aujourd'hui, de façon à ce que les organisations soient contraintes de divulguer de façon détaillée l'utilisation commerciale des renseignements personnels du consommateur. Je réfère ici au principe 4.8.2 de la loi fédérale qui prévoit qu'une organisation doit divulguer au public la description du genre de renseignements personnels que possède l'organisation, y compris une explication générale de l'usage auquel ils sont destinés. Je note que ce principe-là ne demande pas aux organisations, comme les agences de crédit par exemple, de préciser exactement les services commerciaux offerts avec ces renseignements personnels. Dans un contexte où les entreprises privées monétisent de plus en plus les renseignements personnels des individus, cette précision pourrait peut-être s'avérer essentielle pour informer convenablement les consommateurs. Une deuxième solution serait simplement d'inviter les acteurs du système d'octroi du crédit au Canada à modifier leur clause de consentement en matière de protection de la vie privée, en énonçant directement les types de renseignements personnels échangés avec les agences de crédit et les fins visées pour chaque type de renseignement personnel énoncé, incluant, pourquoi pas, les utilisations éventuelles de ces renseignements personnels. Formellement, cette information pourrait être simplement affichée dans un tableau indiquant pour chaque type de renseignement personnel recueilli ou communiqué les fins afférentes. Divulguer l'information, c'est une chose, s'assurer que les consommateurs en comprennent la substance en est une autre. Dans nos entrevues avec les consommateurs, nous avons constaté que des individus retiennent plus facilement l'information sur une enquête de crédit lorsqu'on leur est communiqué verbalement. De plus, plusieurs personnes considèrent la lecture des diverses stipulations contractuelles, qui sont écrites souvent en très petits caractères, tout simplement rebutantes. En conséquence, il pourrait peut-être être pertinent de contraindre la divulgation d'informations essentielles concernant l'échange de renseignements personnels avec les agences de crédit de manière vulgarisée aux consommateurs. Ici, on pourrait peut-être envisager le recours au formalisme contractuel ou à l'obligation de divulgation verbale complémentaire, comme c'est d'ailleurs actuellement le cas dans d'autres domaines de la protection du consommateur. Finalement, je note que la question de la transparence que je viens de traiter de manière très brève n'est qu'une des conclusions de la recherche que nous avons effectuée, qui s'intéressait, comme je le mentionnais plus tôt, à la légitimité de ces utilisations des renseignements personnels. Je soulève quelques autres enjeux qu'on a traités dans cette recherche-là. C'est une liste évidemment non exhaustive. D'abord, certains dangers peuvent se profiler pour les consommateurs à l'égard de ces nouveaux services. Par exemple, les services de marketing visant à permettre aux entreprises et les nouveaux clients, sans obtenir leur consentement, fournissent ce qu'on appelle des données agrégées, des données agrégées ici par code postal. Or, on peut se demander, dans le contexte où le code postal, où on parle de groupes d'une dizaine de personnes, on peut se demander si le travail de dépersonnalisation des agences est suffisant pour éviter les risques de repersonnalisation ou de réidentification des données. Un autre danger, c'est dans l'exactitude des données du dossier de crédit. Bien qu'il n'y ait pas d'études équivalentes au Canada, une étude récente du Federal Trade Commission aux États-Unis mentionne que 26% des dossiers de crédit contiennent des erreurs et que 5% de celles-ci pourraient entraîner un impact négatif pour le consommateur. Du fait de la multiplication des services offerts par les agences, ces erreurs pourraient avoir des conséquences dans une multitude d'aspects de la vie du consommateur. D'abord, évidemment, les conséquences financières. L'obtention du crédit devient plus difficile du fait d'un mauvais crédit et le coût du crédit finalement obtenu sera lui aussi plus élevé. Mais les conséquences touchent désormais d'autres domaines. Par exemple, un mauvais dossier de crédit peut constituer un motif de refus d'embauche. Il peut presque doubler le montant de la prime d'assurance consommateur. Une personne peut même se voir refuser un logement par un locataire qui recourt aux agences de crédit pour vérifier ses antécédents. En guise de conclusion, je mentionne le manque d'information, la méconnaissance des consommateurs des pratiques des agences de crédit, les risques potentiels auxquels ils s'exposent et la faible acceptabilité sociale de certaines de leurs pratiques nous ont aussi amené à nous questionner sur les limites de la liberté contractuelle dans la loi. Compte tenu du choix souvent peu éclairé qu'effectue le consommateur en matière de vie privée, devrait-on envisager d'adopter une approche prohibitive dans laquelle on interdirait certaines utilisations du dossier de crédit? Cette question-là en ouvre une autre. Au Canada, on laisse aux créanciers le choix des outils de gestion de leurs risques. Devrait-on tout simplement contraindre les créanciers ou les entreprises à adopter des modes précis de gestion des risques? Bon, évidemment, notre recherche ne tranche pas définitivement ces questions qui nécessiteront manifestement davantage de réflexion. Je vous invite à lire notre rapport lorsqu'il sera publié pour connaître les détails et les autres points que je n'ai pas malheureusement eu le temps d'aborder. Merci.
So, good afternoon, everybody. My name is not Anastasios Vincent or Tazos. My name is Avner Levin. I'm standing here filling in for Tazos, who's the lead researcher and the recipient of funding from the contributions program for this year to the study that was conducted mainly at Sherbrooke with some participation on our behalf down here at Ryerson University. So I'm here thanks to Tazos, and also here thanks to my dear colleague who's here today with us, Professor Jamie from Ryerson, who gave me an opportunity at Ryerson all those years ago. So hi Jamie, thank you for coming here today. We're going to talk a little bit about the financial aggregation industry, some of the risks, and a survey that was conducted out of Sherbrooke into the consumer attitudes, and also talk a little bit about the frustration with the industry as a whole, because I think that's sort of a theme that's running through today in the various industries and the various conversations. So, and hopefully we'll be able to answer less. Okay, so let's start with sort of overview of what financial aggregators are. So these are businesses, and our definition, they're not banks, so banks fulfill the same functions that collect the data, which is financial in nature and mind, group the data together, and present it to customers within a single interface. The customer's various transactions, there's banking, investments, credit accounts are aggregated together and offered for these aggregators, either for a fee or for free. And the aggregating technologies and the storage technologies, they are on both sides and raise both privacy and security concerns, which is what the project was going to probe. Let me talk a little bit about the industry that we're talking about. Primarily, this industry is in the United States. It targets the US market, but it also is expanding internationally. We have about half a dozen firms when we did the research together with Sherbrooke that we saw were sort of active in Canada and sort of active. There's some targeting, not targeting in Canada. One of the firms that we noted are Mint, who is the sort of mobile arm of Quicken, for those who know Quicken, Yodlee. These are the sort of two major players right now. There's also other players, IBAN, which is in the UK, primarily checking something called envelopes, and Pockets. And then we will talk a little bit about the role of banks. And as I said, the industry primarily is we define it. It's not through banks, but it's running through banks. Let me just pause here because we're going to do a survey. I wanted to do my own very scientific survey right now, right this second. Has anybody in this room ever used a financial aggregator for their banks? Anybody? One person? Raise it high so everybody knows. Two, can you tell us which of the ones are there? Mint? Yeah. Mint? Yeah. And so that's, you can see the percentage there. Anybody use their own bank's app on a phone? Raise your hand, your bank app on a phone. Okay, your bank access through a mobile device like a tablet? No, like through an iPad? Through a desktop? Anybody does banking? Yeah, okay. So I guess the survey is scientific, we'll see in a second on that. But it's very telling, and we'll get to that in a minute. Briefly, before we get to talk about the project, of the regulators that are dealing here, and this is partially one of the issues that we're seeing going forward out of this project. Canadian regulators on the whole are not yet, we say, very active in this field. There is a regulator called the Financial Consumer Agency of Canada that has issued a warning, and this is a warning verbatim. You should put it in quotation marks of the possible threats financial aggregation may present to Canadian consumers, recommends the cautionary use of these sites, et cetera, et cetera, et cetera. That's on the financial side. You know, the Office of the Private Solution just funded this project, so they took an interest from that perspective for sure. We'll talk more about that, I think, towards the end of the time. And several other jurisdictions, Canada including, have also set these various committees to sort of examine the privacy and the fraud issues that may arise from the extensive of services and consider possible solutions. But this is all very, very sort of rudimentary. This is all sort of like you'd see in the Bitcoin conversation that's going on. Should we regulate it and stifle it? Should we just let people innovate? That some people will lose money in Japan or something like that. This is sort of what happens. So I think that with respect to the financial aggregators, pretty much just sort of wait and see approach on behalf of regulators. Don't want to regulate it too heavily, but as we will talk, we think that there's some issues there that perhaps they want to take a look at. Let me talk briefly about the technologies that the aggregators use. Very simple terms, because I don't understand it myself. There's two of them. One is called screen scraping, broadly speaking, and that's the cheap and dirty version. And then you've got the direct feed technology, and that one is more work but more secure. I'll talk a little bit about each of them. Screen scraping does not need human involvement. You provide the aggregator, your customer's username and password for your various accounts, and then the aggregator runs a piece of software that automatically, sort of on your behalf, as if it were you, enters your username and password into those accounts, and then the information comes up, and the aggregator then collects that information, or scrapes it, so to speak, and then brings it into its own interface on a single page for you, and that's how you get to see it convenient. There are variations of this technology. One is called the user-driven model, and one is called a third-party model. Basically, that relates to where that information is stored, so that's the sort of second piece of technology. In the user-driven model, by and large, information is stored on the user's device. Let's say it's a desktop computer, for example, if you're using not the app, but a sort of online version or a notebook or whatever it is that you're using, it will be stored there in some kind of technological equivalent. We call it a safe or a vault, and that's under your control. The third-party model is cloud services, and that raises a whole host of other issues in terms of who is managing that cloud, where is that storage going to, et cetera, et cetera, et cetera. So those are the two. But regardless, the appeal of the screen scraping technology is that it's fast and that it's cheap for the aggregators to use. Direct feed technology, this is sort of business-to-business interaction happening in the back. And they're not able to, if they adopt that model, they don't access the financial information unless they can prove to, and this is sort of a legal sense of proof and agreement kind of sense in the financial institution where your data is held, that you have actually authorized their access. That, just to open up brackets, creates issues around your personal liability if something goes wrong. Because if you all are familiar with your credit card agreements, you will know that you are liable for transactions that you authorize, and that you are only sort of off the hook if it's an unauthorized transaction, that kind of fraud scenarios that you skim your card, etc. So the banks are treating these as authorized transactions, which means that you are on the hook for something that happens, and that's a very sort of interesting way for the banks to both, we think, carve themselves a niche in this market when they want to move into it, but also just not have to worry about these issues and put them back to consumers if that happens. So they have to have all of this information, and then they have to adopt this communications protocol with the bank, and they have to sort of, maintain these sort of technological standards if they want to get the information like that. And then again, all that information that they collect from the various banks and other credit cards or whoever it is, that all comes and is in on the website for you to see. It is more costly for them, and as the technology gets slower. So these are two things that work against the industry adopting this type of technology. Okay. So the concern, of course, from a business-driven enterprise here is that they would use the lowest cost available, screen scraping one, and the cloud one to that, which is even easier for them to manage. There's this, et cetera. Just talk. So let's talk about minutes that we have left about what Sherbrooke actually did in terms of their project. So developed questionnaires and interviewed guys and try to get information about what is the attitude of Canadians towards these aggregation services, what are the attitudes of the aggregators towards technology that they use to protect consumers' privacy and identity. The industry has refused to participate. That's the part that is Ryerson's failure. We were not able to get anybody to talk to us about this, not even to say, oh, we comply with the idea. They weren't even able to say, I don't know why, but it's not as if we can check. But I think it's a recurring theme today that we sort of see that the industry is just like saying thanks, but no thanks if they answer it all. It's really concerning, I think, from our perspective. Please, here's a quote from Yodlee. There's no offsite for us. So thank you, Yodlee. I'd like to plug Yodlee. I'm happy that the two users here are but Lynn didn't even answer. So Yodlee, at least I presented this at the top. That's for Yodlee. So what we're presenting today are the attitudes of consumers as collected through online surveys that were done in Quebec and we've done in Ontario. Here they are. Mainly what Tazos wanted to do was try to see if you can compare Anglophone and Francophone attitudes as well towards this. And so we tried to distribute it amongst two different populations, Ontario, Quebec. On average, and I think we have a bit of a problem here. It's hard for me to sort of analyze this and again sort of accepting it. I think we had a different kind of sample that we had targeted, so I'm not sure if this is representative of Quebec versus or Francophone versus Anglophone, but this is what's coming out of the data and sample that the Anglophones here were. These were the characteristics, and the francophones, and Sazos said to me when he thinks that they were mostly students. So that accounts for the explanations. But it's interesting always to see the younger perspective there as well. I won't go through this chart with you because I have it in graphic form, but the slides will be available. I'll show you some bar charts that sort of come out of the various results, and these are all in percentages. So a question about income, I don't know if you can see that, I guess you can see it over there. So you can see how the income is skewed lower in the francophone because these are students that aren't making any money. Degrees, again, most people in bachelor's. Gender, as you noted. Trusting technology. So the question is, do you trust the encryption technology? And I think what emerges out of here, at least in the survey, is that people are saying, yes, we trust them. The people that are using this technology, remember this is a survey that already selected people that said that they're using it. It's not, so a lot of people here are not using it, but the people that said this is the reason that they're, one of the reasons that they're saying is that they're happy. Okay. I don't know that this is any surprise to anybody in this room. You read their privacy policy. Of course, most people say no. And so, although it was interesting, again, sort of split here in terms of Ontario and Quebec. Quebec said no. Ontario did say yes. It's also probably the sample is skewed there. I was thinking about that because when we sent it to people that are interested in privacy issues. So that in itself, people that are already there. What is your level of concern with respect to privacy, identity theft, and fraud? So we see a fair bit of concern there that is sort of juxtaposed against that level of trust in the technology. So that's another familiar privacy conversation, which people say that they are concerned about their privacy, yet behave because they're trusting the technology in ways that you could argue are not that careful. Have you ever changed your attitude? So again, the majority said as well, I don't see any need to change my attitude towards using these various forms. Is there a platform that you trust more? Interestingly, that most people that are using do not indicate their phone as a platform. Only a small portion there said that they don't use the platform, and what I would consider like the old type of computing devices, the desktop and the laptop lumped together are sort of those that people by and large using that. I think was reflected in the room. When we sort of asked how people use banking, and people are using it on the desktop or on their laptop, but they're not using it in other ways. And whether if you're asking, are you willing to use a virtual bank financial institution, but it doesn't have an existing privacy policy? Again, the Ontario sample, which is more privacy aware, I would say, said pretty much no, but there are in Quebec certainly people that were willing to say yes occasionally. And we always want to ask, are they willing to pay for privacy? It was very interesting that kind of, we put that statement there, refuse to pay because, we sort of giving them this, which arguably says a leading statement that this is the right. We wanted to probe that it came up in repeated surveys that sometimes people refuse to pay because they think it's a right and therefore it's something that the government should do for them. So we always think that people don't want to pay because they don't want to pay any kind of amount, they want to get it for free. But we're also interested in probing whether there's an attitude there that says actually government should take care of this for me. And it shouldn't have to be paying for that, just like I don't want to sort of feel that I'm giving, paying directly for the firefighter coming to put out the fire. Right? It should be a government thing and social good that people do. So again, I'm hearing more people say that. If people are willing to pay anything at all, it's very low amounts. And so some tentative conclusions, and with that, I think we'll end. This is a familiar sort of thing that we're seeing. Consumers exist technology is trusted. Consumers are motivated by convenience. We would say that it remains for us the key factor here is that people see that if it's convenient, they will use it overwhelmingly over anything else. Maybe they differ, maybe not. I don't think that our sample was good enough that we can sort of draw this conclusion. We'll see if it stays in our final report or not. Certainly, the bar charts are different, but it's difficult to say. The industry refusal to cooperate we found to be very concerning. And I actually want to use the time not to sort of launch it by radio, but a little bit of a rant against we've been trying for years to get the cooperation of the financial services industry on a variety of projects to sort of get some kind of cooperation and sense from them in terms of data breaches, where the sources are, what's happening with respect to rogue employees, or these attacks from overseas, or these consumers that are just, putting a pin on their forehead and walking around and people are stealing it like that. What exactly is happening? RBC don't tell me, people don't tell me. Tell me as an industry, at least we'd like to know. And there's always been a refusal on behalf of the big banks to do anything like that, on behalf of the CBA to do anything like that, and on behalf of these new entrants to do anything like that. Refusal to discuss that at all. And I think that, or I hope, what I would say is that the projects that are here today that are funded by the Privacy Commissioner, I think it would be a great thing if the Privacy Commissioner, possibly other regulators, would actually take these projects and go back to the industry with them and say, look, let's have a conversation as a regulator and see what is it that, why don't you want to participate? Why don't you want to talk to the academic world? We've got research findings that we are presenting to you that we can sort of say people have concerns and they refuse to talk. We think the academics are biased. What is it exactly? I think that would be a great sort of next step. It would be really, really, I think, a useful, good use for the projects that are funded. It's one thing to sort of just allow us to get funding. I think everybody in this room is grateful, but it's great also if we could see some policy changes as a result of having these projects play a role. Because I think that's really, really a welcome conclusion to this day, and that's another one that we're sort of always debating. And I think the other interesting question, and this is specific context, but I think it came out today as well with other contexts, is who's the lead regulator? Or at least what are the regulators talking to each other? Are they having a conversation? I think a lot of the time we see that regulators are sort of either just doing their own thing or just ignoring, and I think financials, drones, ISPs, whatever it is, social media, it really is a good idea to have a conversation among the regulators to see what roles are each regulator playing and make sure that all the regulators are playing their appropriate roles so that an industry player, when they're signing up, knows that this is what they have to face and these are the parties that they have to deal with. And that's it for that presentation. Thank you. And
hello, everyone. I thought I'd start on the last panelist on the last panel by thanking the various partners, University of Toronto, CCLA, Ryerson, CPAC, University of Sherbrooke, and of course the OPC for its funding and assistance. And I'd finally like to add my congratulations to Sukan for her recent appointment. I know you'll be a powerful advocate for civil liberties for all Canadians, so that's wonderful news for Canada. I'm going to talk about tax legislation. I thought maybe I'd preface my comments with a quick general comment about financial privacy. I suspect some of you are in the audience saying, what's happened. We were talking about online profiling, Snowden, NSA searches, online profile, genetic profiling, and so on. Andrew Clement showed us some pretty cool graphics earlier, and now we're dealing with the least sexy topic imaginable, financial privacy. I disagree in terms of the sexiness. In fact, last year the OPC commissioned a poll and asked Canadians, what's your biggest privacy concern? And the #1 answer was financial privacy. So for myself and my other panelists, if anybody accuses us of engaging in this kind of non-sexy work, we can now wave that poll in front of them and make the claim that we're just as sexy as the other folks who appeared before. So I'm going to talk about taxpayer privacy. I'll start by explaining why I think it's an important thing. Then I'll speak to U.S. legislation that even the acronym I think may scare some of you. FATCA, Foreign Account Tax Compliance Act, and a recent agreement between Canada and the United States to implement this act, the IGA, the Intergovernmental Agreement, just signed last month, February 5th of this year. I'll discuss how FATCA, as well as the IGA, erode Canadian privacy interests, and then I'll ask what we can do about it. I'm not advancing this as easily as I thought I would be able to. In terms of taxpayer privacy, it's generally considered to be a very sensitive form of information, taxpayer information. A co-author and I, Jonah Mail, last year did traced some of the historical origins. Why do people care so much about taxpayer privacy? In fact, some of the very earliest laws in the Western world can be traced back to taxpayer concerns in the 12th, 13th century in England in particular. Countries for many decades have engaged in reciprocal enforcement of each other's civil judgments, but they've refused to enforce each other's tax liabilities. And this is called the revenue rule. There's one exception. There's lots of cross-border tax cooperation between Canada and the United States. And one of the themes I'll try to build in is, why do we need this new regime? We're already effectively cooperating, enforcing each other's tax liabilities, and so on. So here's an overview of the FATCA in terms of some background. Countries like the United States and Canada have been worried that our taxpayers are using offshore banks to engage in offshore tax evasion, putting their money offshore and then willfully not disclosing to their tax authorities the amounts of the assets or the income attributable to the assets. And there's been some hearings by the U.S. Senate. We've had a standing committee in finance the last 3 years, part of our Department of Finance conducting a similar review. The most recent big scandals are the 2008-2009 USB Swiss bank scandal, where it was revealed that this particular Swiss bank, partly owned by the Swiss government, was putting bank officials on a plane, flying them to big U.S. cities, and advising high net worth individuals how to engage in offshore tax evasion. The same bank, the U.S. Senate investigation revealed, maintained the so-called Canada desk, and so they were flying individuals to Toronto, Montreal, and Vancouver, doing the same thing. And then even more recently, there was a data dump received by Washington, D.C. based International Consortium for Investigative Journalists last April 2013, and it revealed over 2.5 million documents surrounding offshore tax evasion. Over 5,000 Americans engaged in this activity at U.S. beach. There was tens of thousands. And again, the ICIJ also revealed over 500 Canadians with secret offshore accounts, primarily the Cook Islands, British Virgin Islands, and Singapore. So there is evidence that both Americans and Canadians are illegally squirreling their money offshore. And so in 2010, Congress responds, they passed FATCA. FATCA actually had initially failed to pass Congress. It was brought back up as part of something called the HIRE Act, which was designed really to stimulate employment in post-2008 global financial crash. How does FATCA work? Again, a very brief overview. What it does is that from an American perspective, let me just back up for a second. The United States has an interesting and very unusual international tax law. If you're a U.S. citizen, or I'll get into this, other U.S. expats, you must file a tax return with the United States every year, another document called an FBAR, a Foreign Bank Account Report. Pretty much all other countries don't follow that approach. One exception, no other country in the world that follows the U.S. approach is Patricia, which is a tyrant state in Africa. But the rest of us just tax you on the basis of residency. So if you're living in Canada, you're a resident, even if you're a foreigner living here working, we'll tax you. Once you leave and you're gone for a while, we'll quit taxing you. But that's not the American approach, which leads to this FATCA problem. And so when they passed FATCA, they said, well, all foreign banks, we're going to force you to conduct due diligence, create new know your customer laws, and sift through your file, determine if you've got any U.S. expats holding accounts. Again, it's broader than U.S. citizens. I'll get into this in a little bit more detail in a moment. It includes green card holders, former green card holders, other tax residents, joint account holders, and so on. So you have to, if you're the CIBC in Toronto, you've got to look through your files, figure out if you've got any expat Yanks on file. They could be fully dual citizens or they're Canadian citizens as well. Get that account information and send it directly to the IRS. And the problem for a lot of these expats, they don't necessarily fear owing the U.S. any tax liabilities in a complicated way. Canada has higher tax rates. So if you're working here in Canada and you're paying taxes to the Canadian government, you get a foreign tax credit offset, and you won't owe the Americans any taxes, but it's a penalty regime, both FATCA and FBAR. So every year you don't follow through on your legal obligation to file an FBAR, there's a $10,000 penalty. If you don't file a tax return, in some circumstances, the penalty goes to 50% of your undisclosed assets. That's each year. So if you've got $1 million in assets in an account, you don't disclose it, one penalty is $500,000. There's interest penalties, there's criminal sanctions, and increasingly there's fears of denial of entry into the United States, and there's at least anecdotal evidence that U.S. Customs Guard are in fact following through on that and denying entry. This is a great concern for a lot of U.S. expats living in Canada. So under Canadian law, you can't let a foreign government simply come in and push us around. Well, we'll see in a moment that's exactly what happened. But you can't say to the CIBC, give us all your stuff. If the CIBC did that, they would violate the FATCA and other Canadian laws. I'll get into the FATCA, the Personal Information Protection Electronic Documents Act, in a moment. As a result, the United States started entering into these intergovernmental agreements with countries like Canada to implement it. And so it's basically FATCA, but there's a slight change. Instead of the information, the bank information, on Canadians heading directly south of the border, first it goes to our tax authorities, the CRA, Canada Revenue Agency, and then they hand it over to the Americans. So it's not a sea change, but it does, and we'll see, help the IGA comply with all relevant Canadian laws, or arguably helps it comply. This was a very unusual move for the United States. Historically, they've engaged in significant tax cooperation, not just with Canada, but with other countries. We already automatically share tax information pursuant to the Canada-U.S. Tax Treaty. That's a bilateral agreement that Canada entered into to govern the interaction of the two national tax systems. So we've got this incredible amount of historic tax cooperation. It really stunned people to see this departure from historic U.S. practices. I mean, some people will say, well, we could have imagined the Bush administration doing this, and so they're quite upset, understandably, with Obama, and his fingerprints are all over this piece of legislation. The Americans, in part, what's driving this, it's not politically feasible to tax residents, people who actually make money, businesses and other individual actors within their country. But of course, it's easy to kind of beat up on expats and say, we're going off after these offshore tax cheats. In fact, they're really going after residents using corrupt offshore banks, not Canadian banks. If you're a crook, why would you possibly go to the downtown CIBC here in Toronto? No, you go to the Cayman Islands, Switzerland, Liechtenstein, Luxembourg, other countries that have bank secrecy laws that will help you hide your stuff. So Professor Alison Christians at McGill and I submitted extensive comments last week to the Department of Finance on this issue. We have significant privacy concerns. In part, there's a clause within this intergovernmental agreement, this proposed agreement, not legislation yet, that will trump a number of Canadian laws. I'll list just a few of them in a moment. And so I mentioned earlier the Personal Information Protection and Electronic Documents Act. That's our big federal legislation. We've heard earlier there's relevant provincial legislation in place. It also creates an incredible constitutional issue. The IGA cures the FATCA, but not the provincial legislation. Anyhow, it's a tricky issue. I won't go into it. So under FATCA, all Canadians are guaranteed certain privacy rights when a bank collects your information. Well, the IGA simply comes along and says, to the extent that there's a provision in any other Canadian law that's inconsistent with the IGA wins. And so that's how our government's decided to resolve this issue, simply by ignoring all of our privacy rights and our privacy laws and a number of other laws as well. And so there are privacy laws, limited privacy protections under the U.S.-Canada Treaty and Tax Treaty, and those remain in place. But it's nothing like the Privacy Act. So in terms of some more specific privacy concerns, again, the law applies broadly to what's defined under the FATCA as U.S. persons. So you've got roughly 1 million U.S. citizens living in Canada. Again, they're often, or the majority of them are dual citizens. So these are Canadian citizens as well. It applies to former and current green card holders that are resident in Canada. So imagine if you're a professor on a green card, you work for one semester at a particular American university, you're now a former green card holder. When you come back for the rest of your life, you must file a U.S. tax return, an FBAR, and so on. It is very expensive stuff to comply with this regime. That's the main reason why all these law-abiding Canadians are not complying. They don't want to spend $5,000, $10,000, $50,000 to get back into compliance. So also accidental American. Say you're born to a U.S. citizen parent, you've never stepped into Canada, it still applies to you. Your parents were there briefly, they returned to Canada, and so you only lived in the U.S. for say 3 months. The legislation will continue to apply to you here in Canada for the rest of your life. Snowbirds, there's hundreds of thousands, maybe more Canadians who've head south there. You're quite jealous this winter of those folks. But under U.S. tax law, there's a facts and circumstances test that applies. They too might be trapped, many of them, by FATCA. So many of them are worried it'll inhibit cross-border mobility in a number of different ways. In the history of our country, nothing like this has happened. There's never been a time where we voluntarily complied with a unilateral demand by a foreign government and given away such sensitive personal information. So some more concerns. This affects all Canadians. If the Department of Finance gets its way, this legislation kicks in July 1st of this year. If you open a new account, you'll have to follow new processes that are demanded by FATCA. They're called self-certification processes. So if you open up just a simple deposit account, you'll now be faced with these questions, essentially asking you, are you a U.S. person? Which from a legal perspective is actually quite complex. You might have to hire an immigration lawyer. Who knows what's going to happen? This applies to all Canadian bank consumers, and it's very expensive for the banks to develop this. It's going to cost over $100 million per bank, massive compliance costs, and so on. I have significant commercial confidentiality concerns as well. All Canadian business entities, corporations, and so on that have substantial U.S. owners must remit the account information to the United States. So briefly, here are some of the legislation overridden by the IGA. The Canada Privacy Act governs information collection practices by all Canadian federal government agencies. The Access to Banking Services Act, NAFTA, one of my areas of right. We have a free trade area. We're not supposed to discriminate against each other's nationals or financial institutions. In my opinion, FATCA and the IGA does so. A number of lawyers are preparing charter cases. They think this violates the charter's unreasonable cert provisions, Section 7, life and liberty, and so on. But who's going to win? Well, the Joint Committee, Congress, part of the Treasury Department effort, estimates that globally, FATCA will raise $10 billion over 10 years, which, if you're aware of the U.S. fiscal situation, it's not even a drop in the fiscal bucket. So it's hardly money. I wrote an article last year for the Virginia Tax Review arguing that, in fact, the Americans kind of shot themselves in the foot in that sense that they always cooperated and they signaled to the marketplace that they were, that they behaved. And now they're outliers, and a lot of folks are yanking their money out of U.S. banks, the Florida Bankers Association, and the Texas Bankers Association has sued the Treasury Department, for instance. So the main winners in this article, from my perspective, are lawyers, accountants, wonderful news from my students, business school students here and in Ryerson and elsewhere. Bankers love this, IT consultants. I can go on about some stories, but a typical file, a grandmother who's 7 years old and doesn't know the U.S. needs taxes, but she hasn't filed for 20 years, it's going to cost her $10,000s of dollars. And I know many more horror stories than that. I sometimes joke that implementing legislation should have been renamed the Hire Lawyers, Accountants, and Bankers Act, which, not a traditionally marginalized group that you want to necessarily help with employment, to boost employment. So, in conclusion, what can we do here in Canada? Boy, I think it's very hard to stop this dreadnought. There's so much momentum. I didn't get into this, but why have we done this? Well, the Americans, for the first time, have threatened to impose effectively economic sanctions on us if we don't. Complicated withholding tax on all our banks will be applied if we didn't enter into this agreement, which would shut down the financial industry. They held a gun to our head. And so our finance minister now, Corwin Flaherty, maybe this is one of the reasons he's gone. He was one of the world's biggest critics of FATCA. But eventually we decided to play ball. There is, understandably, we have to have banks. But why are we accepting, unquestionably, this strange U.S. unilateral behavior? We've never done it before. We've never accepted it in the past. Professor Christian and I say that now that we've signed this agreement, we're in compliance. Let's take some time. Let's study the legislation, study some of the relevant privacy implications, for instance. And I think also the government should not fall under sway of this economic sanction. They should use the appropriate legal routes under NAFTA, maybe the World Trade Organization agreements and elsewhere, to challenge the legality of this legislation. Canada and the United States have a unique economic and really human type of environment. There's more trade flows between our two countries, over $2 billion a day, than any other countries in the history of the world. More human flows as well, not Mexico, to my American friends here. So, why are we doing this? And why is Canada subject to the same regime that the Cayman Islands is, the Bahamas, Liechtenstein, Switzerland, and so on? To me, it's unhelpful. It will not help resolve this international problem of offshore tax evasion. In fact, it will inhibit our fight against that problem. Thank you.
We'll take this.
We ran a little bit over time. We started on time, but the last session was a little late. We have about 5 minutes for questions. Any questions?
Well, my comments are directed primarily to the Office of the Privacy Commissioner. I've been living up here 40 years. I've been a citizen for 20 years. I'm a university professor. I write Canadian books. And when I swore allegiance to the Queen, I was told that I was going to have the responsibilities and protections of that. Similarly, I teach human rights. And I talk about the Charter of Rights, about non-discrimination on the basis of national origin. And all I can say is that the Canadian government, the Chinese government, suddenly announced that anybody who was born in China would have to have their bank records turned over to the Chinese government. I wonder what the reaction would be. So we're dealing with 1 million people, plus all their children. My little guy's lucky, he was adopted. So he doesn't have to worry about poverty for the rest of his life. But if any of you were born in the U.S. and lived there for more than 15 years and have children, you're included in this as well. And if you happen to have a spouse with the same last name, you're in trouble also. But as I said to the nice person from the Integrity Office, not the Integrity Office, the whatever office that sponsored this, if you can't speak up about this, then we shouldn't even bother with anything else. Anyway, thank you. I don't want to take response. So.
Okay, I think you're going to say that I should listen to you in terms of the information that you're reporting. I heard about these changes, to the news on the radio, and I said to myself, I'm going to go down to the consulate, U.S. consulate, and find out what's going on in the United States. Years ago, I was there for about, like 27 years or something like that. And I have lived in different countries. Now I have U.S. citizenship and Canadian citizenship. And when I went down there, the representative at the consulate just downplayed everything and told me, oh, don't worry about it at your age, the time that you've been away, you don't have to worry about that. I asked about the income tax because when you leave, and particularly at the time that I left, you don't get any information about what your obligations are as far as the U.S. government is concerned. So I said, well, what is this? What does it mean? I haven't filed taxes. I didn't know about that. And he said, oh, it goes back 5 years, but at your age and your situation, I wouldn't worry about it. I was also interviewed in the waiting room. So I think I'm going to go back to the embassy or the consulate and confront them based on the information that I've just gotten from you in terms of what my obligations are. So I don't know if you want to make any comments on that.
Yeah, I think with the consulate told you simply not true. The congressionally designated national taxpayers advocate has been on this file for the last 3 years, and she has all of these stories about how the IRS is pursuing offshore U.S. expats in a very vigorous manner, threatening criminal sanctions and so on. Incidentally, you're probably on the radar now just by stepping into the consulate. You'll send a little letter potentially to the IRS. But there are many horror stories in our country. It's probably happened for quite some time, but in particular because of the fact in the last couple of years, the IRS auditors have ramped up their investigation of U.S. expats living in Canada. I talked to the lawyers who are representing them, quite sympathetic. Some lawyers in this city have raised their fees to $1,000 per hour because they're so busy with these FATCA files. So this is an unprecedented height also in legal fees. Now, great news for the lawyers, not so great for yourself and other U.S. expats.
Short question. Dr. Cockfield, your FATCA lecture comes as a complete surprise to me because the Canadian MPs, especially in the Tory government, have been sending us letters saying that we should be thrilled, and the word is thrilled, I don't know if you've seen these letters, about what a good deal Minister Flaherty negotiated with the U.S. on the IGA. So I'm being a little facetious, but the Tory government would probably disagree with every statement that you've made in these slides. So just have one question on the charter. You've read the charter of Rights and Freedoms. It's a simple document. What do you suspect? Do you, I can't give you, ask you, the definitive question on this, but do you suspect that what Canada wants to do to help the U.S. implement this new IGA legislation, do you suspect that that will contradict Canada's charter?
Well, I'm not a consummate tax lawyer. I'm not a constitutional lawyer, but I have talked to some of them. I've read Peter Hogg's opinion, where he says that absolutely it will violate Section 8 of the charter, maybe other sections as well. We'll have in the future, some people were talking about SASE. That's, I don't want to go too far. My worry is more about corporate espionage. But in any event, we'll have these dossiers on a certain category of Canadians, those who are expats, U.S. tax residents, joint account holders with U.S. citizens, and so on. A foreign government will maintain this, and for the rest of the Canadians, they're exempt from this measure. So that's unequal treatment under the law, just as one example. But if you look at our submission, we talked a little bit about the charter. I'll also mention terms of some political action Elizabeth made, leader of the Green Party issued another policy statement today at her website on FATCA. The NDP Finance Critic is also looking into this as well. But you're right, the Tories initially opposed it, and then curiously, they all went on board. Same thing with the banks. The Canadian banks initially said no, but then they realized, wait a second, our affiliates in the U.S. are saying this is wonderful. By rumor has they drafted the 236 pages of internal code regulations drafted by the U.S. financial industry. And so the bankers love it as well, in part because now the law compels them to upgrade all of their IT systems, and they believe they can pass those costs on to all Canadian bank consumers. So it's a good deal for the banks.
Just to mention this, our little group at this table has retained a lawyer, Joe Harvey, in Vancouver to help us begin a charter challenge.
Hi, I was wondering if you could speak to the transmission of the information to the United States, because it's my understanding that not only will it be uploaded to an internet portal, which speaks to the privacy concerns that have been discussed today, but the individual reports, which are already required, are also, for the first time this year, it's mandatory that the FBAR be uploaded to a portal. So that means that that data is going to cross the border, which already, if I'm correct, subjects it to the Patriot Act and the Homeland Security Acts. And the Conservative government has said that this data is secure, we shouldn't worry about it. If you have nothing to be, you're not guilty of offshore tax evasion, then you shouldn't worry about your data, no problem. So maybe you could speak to, if possible, the privacy implications of electronic uploading and automatic reporting of all of this data, and the fact that it's crossing the border with no controls, basically.
Yeah, briefly, under Canadian law, PETA, as well as to a more limited extent under the Privacy Act, the law says that information data must be stored in a secure fashion and transmitted in such a way to protect privacy through encryption and so on. So we do have a legal regime to protect that. The intergovernmental agreement, the IGA, on the other hand, that trumps the PETA and the Privacy Act, has no such protections at all. Nor are there any under the U.S.-Canada tax treaty. So this is, of course, a very valid concern. I mean, the hope is that, encryption technologies will be used, but there's no legal requirement so far to do so.
Sorry, very quickly, does the ICA specify a length of time in which data can be kept and how it can be disseminated?
No, again, other Canadian laws do speak to that issue, data retention and so on, but not the IDA. It is silent. And same thing with correcting your file. I mean, if you've got a problem, we've heard from Alexandre, issues surrounding correcting credit reports by banks, and this is in PETA as well, presumably under the relevant French privacy protect or Quebec privacy protections. But it's nothing like that in the IGA. There is a provision that if the bank makes an error that's inhibiting the IRS from tracking you, then the file must be corrected. But there is no right of the data subject to have that personal information redacted or corrected in any way.
I think we're going to have a closing remark, and there are people who are actually taking turns on it. So I encourage everyone who has questions for any of our panelists to perhaps catch them after. But I pass it on to. Okay. Thank you very much for your attention.
Thank you all so much. It's been such a scintillating day, really. There's been so much that we've covered. And before I start my closing remarks, I want to thank everybody in the room, all the registrants who have sat here all day, paid attention, and asked such thoughtful questions. So I think we should applaud you for sitting there quietly. Thank you so much. And if you're not a member of CCLA, I invite you to become a member of CCLA. You can still sign up for the sheets. And also to all the participants, please note in your handouts there's a survey. And it's very helpful to the OPC and to us if you would kindly take a few moments to fill out that survey. That would be great. And you can return them to Tasha, who's at the back of the room over there. So a couple of things. I want to also very much thank all of our panelists and presenters who have come here from afar or from near. You did a fascinating job. The discussion on surveillance last night, genetics this morning, the public-private interface, drones, access to social media, financial information and privacy, and Art, you did make tax extremely exciting, as you just noticed. It was amazing, and I think we just touched the tip of the iceberg, and we're all leaving today wanting to know more about the issues, challenges, and potential strategies towards actually realizing privacy in the private sector for Canadians. So it's been terrific. I also very much want to thank the Office of the Privacy Commissioner of Canada for all of your support for making today possible, for the excellent collaboration that we have had with you. And we're very grateful to you, and we're very grateful to you for the research that you fund that's so important as we all figure our way out of and through the various challenges that we face. I would like to announce on behalf of the OPC that within the next few weeks, they will be announcing the recipients of the 2014-2015 Contributions Program funding. The OPC earlier this week completed the external peer review stage of its assessment process, and there have been excellent and innovative proposals that have been received yet again. So the OPC has asked me to tell you to stay tuned and to check their website. I very much want to thank CCLA's other partners in this initiative today. I've already mentioned them at the outset, but that would be the University of Toronto, Ryerson University, CIPIC, and the University of Sherbrooke. In particular, and I'll just go by first name since you know them all today, Avner, Anastasios, Andrew, Tamir. I also very much want to thank the staff of the Canadian Civil Liberties Association. There's just 10 of us, and it takes a lot of work to put this on, and everybody has worked in their own capacity to make today happen, including for some staying up late so they could take today off and be here and join us. So I'm very grateful to all of them. In particular, I'm extremely grateful to Dora Chan and Brenda McPhail for the tremendous work that they have done tirelessly. And our other volunteers as well, in particular Tasha Donnelly, who's at the back, who will be collecting your surveys, and our articling fellow Laura Berger, who did quite a fair bit of research. So thank you all so much, and I hope that you've had a wonderful day, and we should all stay in touch and continue our good work together. Thank you.